science. Yes.
Yes, my lord. Lord, the institution was established in 2015.
Yes.
Lord, when the institution was established, Lord, nobody was having the qualification, so it was on a temporary basis, Lord. So the fourth respondent, Lord, who is the professor and in the Mysore Medical College, Lord, who was the head of the department, who was given an in-charge post of Dean and Director at the Chamarajanagar Institute of Medical Science.
When 2015?
No, Lord, he was appointed on 26/7/2023.
ಅಲ್ಲಿವರೆಗೂ ಯಾರಿದ್ರು?
That was Lord
15 to 23.
Lord earlier, Lord.
ಆಯ್ತು. Why you have approached this court earlier?
Lord, seeking for the same relief, Lord, to fill up the post on regular basis.
Yes, now that who has to done it?
Lord, first respond government, Lord. In fact, Lord,
Government has to.
Yes, why you have not done it, Mister? You want to continue that temporary arrangement,
and
in spite of the specific direction.
Produce the seniority
Have to
list,
get
Lord, where
instructions
all
to
the
file
petitioners are
statement of
eligible to hold the
objections
post.
Otherwise, he is happy. He is enjoying that.
Yes.
Now that there is already a direction.
Yes.
Where is that order?
Page 75, Lord.
Now,
The relevant is that, Lord, 81.
ಅಲ್ಲ ಕಂಟೆಂಪ್ಟ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು.
Contempt ಹಾಕಿದೀನಿ.
ಅದೇ
Not
contempt.
for Lord, it is coming up
Pending.
on 4th of November, 4th of September.
Yes.
4th of September for non-implementing the order of this honorable court.
Similar-
Why you have filed a writ again?
Similar prayer will be barred by
Why you
receipt.
have filed a writ again?
Lord, the direction, Lord, which we have made a representation to the authority to call for a regular post holder.
I'll get instructions
He
in
cannot
this matter.
exercise the powers, statutory powers, Lord, as I'm relying upon the judgment of B.N. Dhotra, Lord, where an additional in-charge post charge holder cannot discharge the duties of a regular post holder. And he is continuing the same post on in-charge basis itself.
I'll get instructions. ಏನಾಗಿದೆ?
Yes.
Sought for interim order, my lord, sir. Let there be a direction, my lord, so not to discharge the kindly see the interim prayer, my lord, in the writ petition. Page 17, my lord. Pending disposal of the above writ petition, the petitioner's respectful prayer that this honorable court be. Pending disposal of the above writ petition, the petitioner's respectful prayer that this honorable court be pleased to stay all decisions or orders made relating to exercise of statutory functions,
Yes.
functioning of the post of dean and director by the fourth respondent, including selection process for the post of teaching faculties.
Yes.
Let there be an interim order, my lord, not to take any.
When do you want, Mr. Government? You get that instruction from the government. Why they are not complying that?
I'll find out.
Yes. You have nothing to do with this, Mr. You have nothing to do in this case.
Yes.
Yes, you are under the mercy of the state government. That's all. Yes. Yes, we will have it on 23rd, Mr.
Please.
Yes. Leave this matter on 23rd.
There be, my lord, the direction, my lord.
No, 23rd.
Not to.
No. That's you have no interim order in that earlier round of litigation.
Lord,
And this
the
also.
specific direction is there, my lord. The government could have, my lord, issued the notification.
That's what now we will
30th
get.
May itself. My
Yes, we'll get that instruction. Why they are not doing? Yes.
lord. Please.
Yes. Dispensation for a period of 4 weeks.
Bill number 36, Ashok Katti for petitioner, N.S. Sriraj Gowda.
That is no.
Yes.
Here the petitioner, my lords, has prayed for appointment and compassionate ground, my lords. Petition is the son, his
Yes.
father, my lords.
Yes.
Now, my lord, as far as the employment details are concerned, in the state, directly back to take my lords the statement of objections.
Now, what is that relief you have sought for?
Now, my lord, the pending consideration, my lord, our instruction is that they are proceeding based on the mother's consent letter, religious consent letter.
What is the
BWSSP rules, I have produced it along with this, my lords. Rules, you will kindly see page number 19 onwards, my lords. 19. Kindly go to page 20, my lords.
50.
Page 20. In the writ petition itself, my lord, please. Page 20.
Yes.
Dependent of a deceased government servant means a member of the family of the deceased government servant who means a member of the family of the deceased government servant who was living with, I stress on living with, and dependent on the deceased government servant. Now she was already married long back, not living with him,
Yes.
not dependent on him. Next, again, my lords, page 21. Family, for the purpose of these rules, in the case of a deceased male married government servant, his widow, son and daughter, unmarried, married, so and so, who were dependent on him and living with him. Two requirements to be fulfilled, my lords. Dependency and living with him. It is not. And if this is fulfilled, my lords, then if there is a contest between the parties, then my lord, mother can give a consent. Kindly see next one, my rules.
The deceased female married government servant is her son, widow who were dependent upon her were living with her. Case of deceased male unmarried government servant.
My lord, only clause 1 is applicable. Others is female, unmarried, etc., etc. Others, first one is only applicable, my lords. Here is a case is a married male government servant.
Is widow.
Widow, son, daughter, all are entitled, my lord, who were dependent on him.
No, where is that consent of that?
Now, my lord, as for this aspect concerned, my lord, page number, next, my lords, next page 22, eligibility for appointment, my lords. Once this is fulfilled, then, my lords, appointment on compassionate grounds, these rules shall not be claimed as a matter of right, shall not be given as a matter of course. Appointment, these rules shall be restricted to dependent of a government servant. I stress on this. Dependent of government servant is again defined, my lords, in the section itself. It says living with him and dependent. Again says, in the case of a deceased male married government servant, widow, son, daughter who is chosen by the widow of the deceased government servant, if the widow is not willing to accept the appointment, who were dependent on him and were living with him.
Yes.
Now, my lord, first condition to be filled up, satisfied is deceased was son or the daughter was residing with these two conditions, my lords. If these two conditions are fulfilled, for example, for both son and the daughter, then the widow, my lord, if she does not want employment, she can say, she can choose.
You have also filed an application.
Yes.
Your sister is also filed an application.
Yes.
Let them decide on that law.
Now, my lord, one aspect
Where
may
you
beg to.
anticipating that they are going to reject you.
Now, my lords, may I beg to submit one aspect kindly, my lords. The statement of objection, lords.
They are given a compassionate appointment to the daughter, then you challenge
Now, my lords,
whether
in the meanwhile,
or they may given to you also. Why do you want to?
may I submit, my lords, she is totally disqualified. Kindly see the statement of objections filed by R6 and R7. They admit the disqualification. They admit the disqualification.
Where is that?
The statement of objections filed by R6 and R7. Yashoda, wife of so and so, affirm and state as follows, my lords. Yashoda is the mother. R6. Kindly see page number 4. Para 14.
Yes.
I say that both my daughter and son-in-law, though employed, etc. It proceeds. Para 14. I state that both my daughter.
ಆಯ್ತು ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು
ಅಲ್ಲ ಅವ್ರು ಹೇಳ್ತಾರೆ ಅಲ್ಲ ಅಫಿಡೇವಿಟ್ ಹಾಕಿ R6 ಹೇಳೋದು.
ಆಯ್ತು
But your lordship may read the entire paragraph notes of 14.
even assuming that whether he is dead or not,
Please.
he has to consider.
No,
The
my lord.
employer has to consider. He has to consider in terms of that rules. Before that, how can you say that they are going to reject you?
No, I am saying, my lord, they are going to consider only the application of.
How can you say that?
Because the instructions are, my lords, they are going to, because it's only on this basis. May I submit, sir? This is on the basis, my lords. Mother has given a consent, therefore we are going to appoint.
No, that is not the law. What
Please,
you
ma'am.
have read, don't think that you are alone knows that. They also knows.
May I also,
If
my
they
lord.
committed a mistake, then you are there to correct it.
No, in the
If I
meanwhile,
may
my
make a
lords,
few
once
submissions.
they issue the order in the case of this nature, one more para 4, your lords may kindly see para 4. Now, my lord, para 4 of this affidavit. Now, my lord, dependency must be on the deceased, they should be dependent. Para 4, my lords, page 2.
ಅಲ್ಲ ಅವ್ರು ಕೊಡಕ್ಕಿಂತ ಮುಂಚೆ ನಾನು ಅವ್ರು ಡಿಪೆಂಡೆಂಟ್ ಅಲ್ಲ ಅವ್ರು ಕೊಡ್ ಯಾಕೆ
On the faith, they admit it, my lords may kindly see, they admit it. They say, my lord,
No, see, person who is seeking for an appointment,
please.
he will not say that I am not eligible.
That's-
Everybody will say eligible.
One sentence may draw my lords can consideration para 4, my lords.
Yes.
Subjected to the entire response of the family rested with my daughter as she was the sole breadwinner of the family. She's earning is also, and her employment you have mentioned is not denied. She's already employed. She's employed already, and she has got one more employment also, my lord, appointment letter I produced.
Yes, Lords, if I may make my submission. Lords, on law, Lords, the question is whether who the mother chooses. Lords. The mother has already chosen the daughter. In the affidavit, Lords, it's very clear that the mother wants the job to be given to the daughter.
Yes.
Lords, and she's also stated the reasons as to why. Now, Lords, Lordship may read 3(2)(I), my Lords, for a second.
Lord, even that is not, this court cannot go because it's a purely what is sought consideration of representation.
Yes, let us see, let him,
Purely
yes.
a personal dispute. Lord,
Yes,
family
let us-
dispute.
3.
Lords, 3(2)(IB).
Yes.
son or daughter who is chosen by the widow of the deceased government servant. My lords, this is to be given importance.
2I,
2IAB.
IAB.
In the
IA
case
here.
of the deceased male married government servant, son or daughter, notes page 22.
Yes, yes.
Son or daughter who is chosen by the widow of the deceased government servant. Notes
Continues next.
if the widow has already chosen
To where
who the
dependent.
job should go to, irrespective of dependency, my lords, it is my submission that irrespective of dependency, the consent should be looked at. If suppose, my lords, his consent is not, the mother's consent is not given to the son, my lords, there is no question of appointment. The question, my lords, the question only is with regard to, my lords, who the consent is given to. If the mother, my lords, in an affidavit says that the son is useless and the son does not do anything and he does not contribute to the family, and if the daughter is the one who take care of the family, my lords, 3(2)(b) will apply.
No, that is
Because-
true. You can say that son cannot be given an appointment to the son. He will not get it.
Because
But the
he's
thing is that
ineligible, my lords,
Daughter
because
will
the
get it
consent.
or not, that is the question.
Because if there is no consent,
No,
he,
no,
my lords,
then-
even if he's a dependent, my lords, job cannot be given.
What I am telling that, if you are not given consent, he will out. But whether you will get it, you means your daughter will get it. You have to satisfy other
My
conditions.
lords, my lords, the
You say that
dependency. My lords, I was living with the father.
ಪರವಾಗಿಲ್ಲ ಅವ್ರದ್ದು ಒಂದ್ ಕಣ್ಣು ಹೋಗ್ಲಿ ಅಂತ ಅಂದ್ರೆ there is
Allala,
no.
angala. I was dependent, my lords, even before marriage and after marriage. The father, my lords, was giving fees to the granddaughter. The question of dependency, my lords, cannot be looked into because consent is already given by the mother.
No, after you given a consent, they have to examine whether you are the dependent or not.
Plus that day will do, my lords, but I am saying they are ineligible because there is no consent. If the mother, my lord, says
No, that's,
that
we are
the
not
job should be
going
given to
that
the son.
part. Let them decide according to that law, then we will come that. Why do you want to come now?
Let
They
them
may-
decide and submit that report to the honorable court, my lords, because if they give effect to that
If
immediately.
If they are consider that daughter, then you come and challenge why she cannot be. Then even then you can satisfy that she cannot be, but you will not get it. Ultimately, unless, see, compassionate appointment to first preference is to that wife to save.
May I submit
He
only one
say that
aspect, my lords?
I am not depending upon anybody, I have my sources, I don't want, then nobody will get it.
May I submit this, my lords, try to impress upon the honorable court, my lords. First is even the widow, everybody, my lords, should satisfy the definition, my lords, of clause B, my lords.
ಆಯ್ತು.
Please.
ಅವೆಲ್ಲ satisfy ಬಿಡಿ.
Once satis-
If widow says that we don't want your appointment,
No, that I humbly, with great respect, I beg to
then
submit.
nobody will get it.
No, it's only, my lords, if both son and daughter both are equally entitled, then widow's statement is applicable. She cannot.
No, in case of deceased male married
Please.
government servant,
Please,
the widow
first,
and
and
son
son
or
or daughter,
who
next,
is
my lords,
chosen by that widow.
my lord, if both, my lords, first condition is either son or daughter, if they are applying for the job, my lords, compassionate appointment, both of them should have been residing together and dependent.
ಅದು ಬಿಡ್ರಿ, first
ಅದು
ಬಿಡ್ರಿ.
My lords, if they
ಇಲ್ದ್ರೆ,
do not satisfy the first
That's-
part, they cannot take benefit
My
of the
lords,
second
if,
part is what I am
uh,
trying to submit.
if both are dependent, my lords, then the question of widow's consent will arise if she is also eligible.
Lords, the dependency is not at all a question.
Dependency is the question,
No.
but it is in a secondary. First, widow give a consent, then only your application is maintainable.
If
Then
the widow, my
second
lords,
thing is
has
management. We are not concerned that.
Please.
If the mother given a consent to her, if
That-
other condition is satisfied,
Please.
if they are given, if you have any right left, you can challenge that. Otherwise.
No, my lord, that aspect, my lords, I only pray my lords to reserve that finding, my lords,
Yes.
because that, my lord's finding will may
Affect-
affect either, my lords.
With liberty to challenge that whenever that situation arises.
Challenge also happens, my lord, it has to go before the trial court.
Huh? ಹೋಗ್ಬೇಕ್ರಿ. ಇದ್ರಲ್ಲಿ
ಈ
ಏನಾದ್ರು
challenge ಅಂದ್ರೆ
there is no
ಇದನ್ನ-
dispute regarding that, he is not in a son.
The son Allah, but now my lord, dependency will come in picture.
Dependency
Then
has to
tomorrow
say by that
they will-
wife. No, if wife is not there, then that other question should arise. If wife is there, she has to give a consent. First preference is her. If she is not entitled or if she is overage, she can give either consent to that son or daughter.
No, in
If
this
she has
case-
not given consent,
In
if
this
she has
case-
not given consent, that nobody can be filed an
Lords, in
application.
this
with
case,
May-
consent
may-
is already
may
given.
limit
The
my-
question of
May
consent, my
limit,
lords,
my lords. In fact, the prayer itself is, my lord, as your lordship just now put it, my lords, that they should consider, the prayer itself is direction to consider my application, my lords, in accordance with the law. Let them consider my prayer, your lords may kindly see. my
Lords,
lords.
if they're now, my lords, ineligible, Lords, their
No,
representation cannot
this
be
is
even
not
looked at.
correct. No, they are giving judgment in advance because the employer, my lords.
ಒಟ್ಲೆ ಆಮೇಲೆ ಬನ್ನಿ ಆಮೇಲೆ
Therefore, your lords may direct that, my lords. Our application be considered within a time limit.
they're saying that application has to be submitted on the consent of that.
Now, this aspect, my lord, if they say it in writing, we'll counter it. That's not the law at all. The law is, my lord, if there are
I will say,
that aspect, with great respect.
If consent is already taken,
That
Lords,
aspect, my lord.
there is no reason for them to go to the authority and ask.
Precondition of mother's consent would arise, my lords, only if both are equally entitled. Because that condition has to be satisfied. If one is entitled to, my lord, other is.
if you want, you can go and file there. If
I have
you
filed.
want- No, if you want to direction from this court,
Please.
we have to be given a direction as per the statute says.
No, my lords,
We cannot
what
divert-
is, my lord, the only limited prayer we are seeking is your application is kept pending. They cannot keep the, I have already filed my application.
No, you suppose.
Please.
Nobody is, they are not related to that family.
Please.
If they are filed an application, that doesn't mean that they have to consider everything. First, we have to show the statutory.
Lords,
So, my
even
lord-
if his application is considered, Lords, there is no consent.
Application ಹಾಕ್ಬಿಟ್ಟು ರಿಟ್ ಹಾಕಿ ನಮಗೆ directions ಕೊಡಿ ಅಂತಾರೆ.
Your lords may kindly see that view of the honorable court, my lords, whether the mother's consent is compulsory or not, my lords. That would arise, that section itself says, both are dependent. For example, if somebody is not dependent, whether the mother can give the consent. That's the question, my lords.
Yes.
That
You
says, my
take
lords,
it- you keep it this matter, you take it after 4 weeks, let us see that, what they.
please.
Yes,
ಅಲ್ಲ,
this
dispose
matter
ಮಾಡಿ.
of 4
Not
weeks.
at all maintainable.
Huh? ಆಯ್ತು ಇರ್ಲಿ, yes, 4
Not
weeks.
at all maintainable.
Huh? ಆಯ್ತು ಇರ್ಲಿ, yes, 4 weeks.
ಅಲ್ಲ.
You can consider their application, if it is rejected, then they will
ಅಲ್ಲ,
challenge, then
ಆಮೇಲೆ-
they will not come
ಅಲ್ಲ,
before the court.
That question will arise if there is a
That can
dispute
be
regarding
recorded,
the
my lord. That can
paternity
be
or the
recorded, my
maternity.
lord. Otherwise, they will not allow us to continue with the.
How can that, they are coming and.
ಅಲ್ಲ, ಅವ್ರು ಆಮೇಲೆ ಅಲ್ಲಿ.
What is this?
My
they
application is
all-
also pending. Because of this issue, my application and my
No,
representation.
no,
is
no, no,
also-
there is no bar. If they are not considered, you file in a writ, we'll direct
My
that
lord, then.
Lords,
in accordance with law. But his case is that he has to establish that there is an.
Let me at least
Lords,
consider
my
his
submission is
representation,
this,
my lord.
if there is no consent, Lords, there is no question of considering their representation.
That will decide.
Lords, if he had the consent of the mother, then, my lords, he could have seeked for these prayers. If there is no consent and if there is express saying in the affidavit, lords, there is nothing left, my lords, for them to say, I have to get.
They
That can
admit
be
their
clarified.
the employment letters are produced, my lords.
Can be
Whether a
clarified.
daughter who is already employed, my lords, can again seek, and that married long back, residing with her husband.
Lords,
My
the
lords,
petitioner is also
may I
employed.
make this
He's been
clear?
employed, my lords, from 2022.
My lord, this can be clarified by this court, my lord. If
Oh,
at
why-
all, if
why-
for this
why
reason,
I
my
have
lord.
to clarify?
No, for this reason, my lord, yeah, we are not able to come, consider his representation
Why? What
also.
is that?
For
What is
this
that
reason, my lord,
legal
they are
hurdles?
coming in my,
Huh?
they are coming in the way that
Oh,
saying
how
not
can
to.
they come?
My lord, now, my lord, what I am saying, my lord, if we consider, my lord, and we think that they are not suitable for the job, now for sure, we'll have to give it to them.
No, your officer unable to do his discharge his duty, don't take that direction from this court. We are not directed to do what he has to do it. Where is that? Is there any stay?
Yeah, there's
Pendency
no
of the you consider it pass an order?
Yes,
Yes.
please.
Leave this matter of 4 weeks.
much of.
Great.
If officer is not able to do it, don't take that order from me, mister. Yes. Yes, madam.
My lord, I've been employed as guest faculty in University of Mysore since 2019. So this is the 6th consecutive academic year that I'm working as guest faculty at School of Law, University of Mysore. And on the pretext, and I've also qualified.
Where is your petition? What is that relief you have sought? Petition.
Prayer, my lord, is at page 13.
ಇಲ್ಲ petition. Yes, madam.
And I've also qualified KCET and NET, my lord, which is an extra A1 and A2.
What is the prior in the writ petition? ma'am?
Prayer in the writ is to
Directing the respondent university to continue with service of
Services
the
of the
petitioner as a guest faculty as may be so and so action without amount violation of. Directing the so and so action without amount violation of. Directing the respondent university not to remove the petitioner from the service as a guest lecturer. Where is your appointment?
My lord, it is annexure B is the first appointment order. That was for the year 2019 and 20. wherein I had 8 hours of workload,
Hmm.
and then it was enhanced to 12 hours of workload from the consecutive years, that is from 2020 onwards. So that is annexure C.
Yes.
So, my lord, on the pretext of an unauthorized protest conducted by some students,
Hmm.
wherein the students claimed lack of infrastructure facilities within the department, and also claimed that that is Tejaswini, has been doing caste discrimination, discrimination based on color, based on the size of people,
Hmm.
and due to all these claims made by them,
Yes.
the university,
If I may, my lord.
and all that,
If I may make a
and
Yes. Yes.
my lord,
Yes.
I want to finish.
Yes.
They hung ಹೇಳಿದ್ದಕ್ಕೆ, they told me to go on leave for 10 days. And
Yes.
obliging to them, I have not gone, my lord. And the registrar evaluation had also promised me that idrinda nimge ಏನು like service ಗೆಲ್ಲ ಏನು ತೊಂದರೆ ಆಗಲ್ಲ, because we don't have the facility of taking compulsory holidays, my lord. But he asked me to do it because they have a lot of political pressure and things like that. And then I also agreed to whatever they told, and I did not come to college for the next 10 days. And like he had told me, right in front of my name, nothing was written, even if I was absent for the full 10 days. They had
Yes.
not mentioned anything. So I signed it and I came. Then the chairman calls me up scolding, why did you come? You should not come at all.
Yes.
They are orally asking me to abstain from coming to duty, my lord, and hence I was forced to file this coming to duty, my lord, and hence I was forced to file this petition. And that on April 17th, I got an interim stay from this honorable court, asking the respondents to continue my services and not to take any action to remove me from the job. Now, in continuation of the interim order, my lord, the respondents have not paid me salary, and they have not allowed me to affix my signature in the attendance book. The attendance book.
You go and file a
was-
contempt.
I will, my lord.
No, you have to file a contempt. See, if our order is violated, it can be implemented by filing in a contempt. We can't pass same order repeatedly again and again.
Yes, my lord,
Go
but
and
the
file a
salary is also not paid. So I have filed an IA for directions as well.
No, salary we will see. First that if you are not allowed you to work, go and file a contempt.
Subsequently, my lord, on 2/7/25, your lordships have not continued.
But the memo, I mean, the reply
But
to.
next academic year, you have not continued.
No, my lord.
You have, why you have not continued? Is there is no workload, or you are replacing another employee?
No, my lord, based on the workload, my lord, since the petitioner was a guest faculty, based on the workload, my lord, we continue the services or not continue the services. Now, so far as this was considered, my lord, we did not see the requirement, my lord, and therefore we have not.
No, that you
My
don't have
lord-
any workload.
No, my lord. With respect to the subjects that were being dealt with, no, my lord.
Yes, what you say about that salary? Why can't you give the salary and
No, my lord,
deposit it?
Lord-
my respectful submission is this, my lord. We as a university, my lord, I should make a fair submission. We don't have anything personal with regard to anybody that's especially working for the university. Now, my lord, when the petition, there is no order or anything from the university side abstaining, nothing in written, my lord. Let them place anything on record to show that the university has asked the petitioner not to come.
No, according
It
to
is,
you,
it is
wait,
self,
how many months they have to pay the salary?
3 months, my lord. For that also, my lord, like she said that I have. For that also, my lord, like she said that I have not been appointed for the next year. My lord, what happens in university is towards the end of the academic year, on the last working day, all guest faculties are relieved. For the exams and for the holidays, we are not
No,
paid.
that is true.
And the next academic year has not yet started. So
Let us see. Next academic year,
nobody has got the appointment order basically.
no, that is what that. If there is a workload, they will appoint you. If there is no workload, you can't force them to appoint because they can't give any salary freely. It is a public money.
Yes.
Now, only thing is that salary for the 3 months.
Yes.
You can't settle and give it, madam.
no, my lord, this.
And give it, madam.
No, my lord, this, my lord, yes, lordships had asked us to place a certain material on record that I will place now. Your lordships had specifically also
What is
said
that
place
monthly salary you are paying?
27,000. my lord.
28,000,
Hmm.
27,800
Yes,
after deduction of
negotiate and
professional
pay
tax.
that money and close that. Madam. When
My
they
lord,
entry order,
my lord, I'll just point out the by placing the CCTV record to show clearly that, and my lord, in the appointment order itself, your lordships may kindly see the requirement of the petitioner, even though it's guest faculty, is supposed to be present in college full time for the convenience of the students in case any doubt and all of that arises, my lord, the academic administrative part of it.
yes.
According to our CCTV footage, my lord, in all fairness, the petitioner is not there. My lord, for any day that is the petitioner has come to college, my lord, the university has no problem that, and my lord, I am undertaking to submit that. For the days the petitioner has come, we will, my lord, pay. Not like this, my lord. From March onwards is what the interim prayer is. I mean,
Not
the IA.
March, my lord, April.
Let me finish, madam. Interim, my lord, is from April onwards. And my lord, your lordship say kindly see.
No, which are
No.
the months you are saying?
My lord,
April, May,
my lord, kindly look at the
April,
object,
May and
the
June.
memo
please, my
filed.
lord. And now the objection to the CCTV footages, I'm not able to see the gender. What are these kind of objections, my lord, to the
My lord, kindly
CCTV
look at,
footage quality is bad. I'm not able to identify the gender. Your lordship, may kindly see the objection, my lord, placed by the petitioner, page number, it's not page, para 6, my lord, of the objections. The quality of the CCTV footage is so poor that it is even hard to recognize the gender of anybody. My lord, once we've placed now and to show that the petitioner is not here, these are the kind of objections that are being raised, that the quality is poor.
Yes.
my lord, my objections filed by me.
No, according to
For
that
production of the
CCTV footage, you can make out that you are present on that day.
My lord, they have produced CCTV footages of morning half an hour, evening half an hour. One thing. Another thing is, my lord, kindly look at
Full
page
days
number.
CCTV footage.
My lord, it's, my lord, the,
I'll provide
What
the
is
pen
Wait,
drive,
wait
my
minute,
lord.
huh?
I'll provide the pen drive if that is the problem. Because when
No,
the
no, no.
honorable
Wait,
court,
madam. Yes, you have produced, you have not produced. full day.
entrance time, my lord, there's a university schedule time. I'll just read out the memo that we've placed, my lord. Additionally, CCTV footage, the memo, my lord.
Yes.
Additionally, CCTV footage that the university was able to retrieve for the period of 1/5/25 to 16/6/25, specifically reviewed during the entry and exit timings, 9:45 a.m. That is way before everybody even enters. So my lord, the petitioner now has to enter at this time. And the timing still 10:30 when classes would have already commenced. And my lord, 4:30 when everybody is exiting till 5. Now, my lord, at some point, it has to be there. It is not there. And now to say that the quality is poor, I'm not able to identify the gender in your
Yes,
CCTV.
at least you have to be there when 9:45 to 10:30
Yes,
when.
ma'am.
Yes.
my lord,
Is
kindly.
it your case that before 9:45 you have entered?
No, my lord, I am a guest faculty who is paid hourly basis. That is clearly mentioned as 12 hours of workload per week. Now, my lord, the precedent in the university is that we are all guest faculties employed on hourly basis. So we come when we have class. My class is at 11 o'clock.
Yes.
My lord, they have produced CCTV footages of 10:30 is what they're telling. What if I entered at 10:31 or 10:30 and 30 seconds later? Because
Okay.
my classes are at
No,
11
is it
o'clock.
permissible? That's what I am asking. What time?
Everybody comes that way. My lord, also to prove my point, kindly in my objections that is filed on 25th
No,
of
how many guest
July.
lecturers are there?
22, my lord.
All are coming in 9:45 to 10:30. You can
No,
make
my
out in
lord.
that CCTV footage.
No, my lord.
All are coming.
Yes, my lord, my lord, that is
My
the
lord, it
general
should be
timing that is
verified.
supposed to be followed.
You make it a statement. You are before the court. All are coming in 9:45 to 10:30. You can make out that. All
We'll
guest
take
faculties,
instructions.
according to you, should be there within the time.
We will take instructions on that point, my lord.
Then
And my lord, no,
file an
apart from that, no,
If-
apart from
see,
that,
Don't take, see, if you are allowed that to guest lecturers to come according to their class timings, she might have been, wait, madam, she might have been come at class time. If your rule says that no, all guest lecturers has to be come before 9:30 to 10:30, whether all guest lecturers has coming, there are how many? 22.
22.
All are coming, then she has to come. Otherwise, she has no case. That you have to be. Otherwise, if you are liberal to all, they have to come according to their class time. Then we have to see that these timings cannot be make out that.
This
Now
one,
you
just
get that
one point.
instruction on that point.
Just one thing I want to point out. Yes, my lord, everything on record already.
Also, my
I will
lord,
answer this.
Yeah, I'll answer.
Then.
Please.
also, my lord, none of the documents that they've submitted is on affidavit. Everything is just documents. They have not filed a single affidavit.
No, if it is
For
required,
any
we'll ask them
documents.
first. Let them. Now you have raised this question. Let them answer that whether they are giving that timings to all or not. Yes. When do you want?
My lord, to
2 weeks,
verify
my
that
lord.
they have to give full day footage, my lord. They can't give half an hour, half an hour.
We will see that if that is the timings, everybody should be there. All 25 should be shown in that half an hour.
Yes.
Otherwise, if they are relaxed, then they have to give full days. That's what. Let them first answer that. Yes.
2 weeks, my lord.
When do you want?
Again, my lord, will have to sit and retrieve the CCTV.
And my lord, they've not produced CCTV for April also. They're telling April also have not come. They have to
No,
prove it
first,
by.
if you prove that this month you have come, then what they are saying is wrong. They have to pay 3 months salary. If it is proves that you are not attended that classes, then you are not entitled for anything. Yes. Is this matter on 10th September?
Agreed.
Yes. Is this matter on 10th September at the request of respondent? Yes.
Cell number 38, Kiran Kumar DK for petitioner, government advocate.
Yes, for petitioner in this case, my lord. Lord, challenging actually a dismissal of a petitioner, the post of Anganwadi worker. The last occasion, my lord, the government has taken time to file objection, but they never filed.
Lord, my colleague, it appears, has taken time, my lord. Some further time may be granted, my lord. I've sought instructions from my.
Yes, at the request of government advocate. For the last chance. 2 weeks.
Is in page number 15, my lords.
14, my lord, para 6.
Is in page number 15, my lords.
14, my lord, para 6. Para 5 in the start.
Yes.
Lord, may I read para 4 in the act? That is very important, my lord.
Yes.
It is also case of the petitioner, she has secured 55.26 where the cutoff marks was 56. It was contended that while considering the percentage of the petitioner due to weightage as ordered by this court was not taken into consideration, and the consequence she has lost 10% weightage. It is submitted that if the petitioner is granted 10% weightage for the 2 years of service rendered by her for the 2 academic year, her percentage would become 56.26, and it is therefore the above cutoff marks has been cutoff percentage. That she is eligible for appointment. The petitioner in this regards has made a representation at Annexure H in view of this, since there is an order passed by this honorable court on the basis of the earlier order which has been affirmed by the honorable Supreme Court. It would be necessary for the respondent number 2 to grant a weightage at the rate of 5% to each academic year, then consider the percentage of the petitioners for the appointment. Since it is contended that they applied with, would be necessary to direct the respondent number 2 to consider the case of the petitioner by granting her weightage at 5% for each academic year for which she has claimed to have been rendered services. The second is percentage in the combined competitive examination, and whether the institute has allotted the relevant weightage as according to work done by the
You are
petitioner.
saying that after giving weightage, its percentage is 52.2%. Is it?
No, my
Mr.?
lords, it is 56.
I will place that
on
note.
dot.
I will place that.
No, where is that materials to show that this doesn't include that weightage? That is the point we have to be see. If it is weightage is included, then cutoff marks, if the weightage is not given to all candidates,
Please, man.
then this cutoff marks will also go increase.
And it is very much clear, my lord. May I read para 3 of that judgment only, my lord? Para 3 of the judgment, my lord. 13, page number 13, para 3. It is case of the petitioner, the institute which she has appointed was established only in the month of August 29. ಅವರಿಗೆ 10 ಬರಲ್ಲ, ಬರಬೇಕಾದ್ರೆ ಏನೋ 2.5 ಬರ್ಬೋದು ಅಷ್ಟೇ ಅಂತ. ಅದನ್ನ I will place that note. August 2009, she was appointed in 1/8/2009, and she has consequent by virtue of the rendering 2 year services for 2, she would be entitled for weightage of 10%.
No, in 9 ಒಂದು 10 ಒಂದು 2 ಇದೆಯಲ್ಲ, 2 ವರ್ಷದ.
ಹೌದು.
Please, my lord.
2 ವರ್ಷದಾಗ ಅಂದ್ರೆ ಇಲ್ಲಿ ಫಸ್ಟ್ ಇಯರ್ ಅಲ್ಲಿ ಪ್ರಪೋರ್ಷನೇಟ್ ಬರ್ತದೆ.
ಅಲ್ಲ, ಈಗ ಎಷ್ಟು ವರ್ಷ ಅವರು ಯಾವಾಗ ಜಾಯಿನ್ ಆಗಿದ್ದೇಳಿ?
That I will place, my lord, that the petitioner has not produced any material to show that they have worked.
Government advocate press.
ಇಲ್ಲ, respondent to advocate ನಾನು.
ನೀವು ಇದಕ್ಕಲ್ವಾ? Yes. Respondents, counsel for respondent number 2 press. How much time is required?
Not only
0.26%, my lords. That's all been considered 0.26%, my lords. That's all been considered in this judgment, my lords. In the same judgment, it has been considered, my lord.
ಇಂದು 2010ರಲ್ಲಿ ಕೆಲಸ ಮಾಡಿರೋದಕ್ಕೆ 5% ಕೊಟ್ಟಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಏನಿದೆ? Who has to say whether it is allotted or not?
ಅಷ್ಟೊತ್ತಿಗೆ ನಾಗೇವರು ಇರಲಿಲ್ಲ, ಅದು ಹಂಗೆ ಪಾಸ್ ಮಾಡಿಬಿಟ್ಟಿದ್ದಾರೆ. He is not in panel.
Whether it is given or not has to be find out from that respondent. If it is not given, then in terms of that they have to allot that 10 marks.
Not that I will place only ಒಂದು ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ಬಿಡ್ತೀನಿ ಅಷ್ಟೇ.
When do you want?
Not 1 week ಅಲ್ಲಿ ಯಾವ್ದಾರು ಒಂದು.
Yes, is this matter? And 21st.
Obliged.
Much only.
Cell number 41 adjourned. Cell number 42, Kulkarni Srinath for petitioner, PC Prabhakar.
Here for the respondent, my lord. Yes. My lord, in this case, I was directed to file my statement of objection.
Yes.
I have served a copy already. I am filing it. But subsequent
On
to
time.
my
No, senior counsel,
served a copy already. I am filing it. But subsequent
On
to
time.
my
no, senior
go through
counsel Vilas Kumar will appear, ma'am.
subsequent to one submission, my lord. Subsequent to my one submission, my lord. Subsequent to my filing the statement of objection, then
For their own time, Mr.
Yeah, appear for respondent in this case, madam.
Where is Nagaraj? Login ಆಗಿದ್ದಾರೆ ಇಲ್ಲ. Yes, none appear for petitioner. Yes. Yes, Mr.
I'm appearing for the petitioner. Petitioner retired in group D cadre in the respondent department on admittedly retired in superannuated on 31/3/20. That is crucial, my lord.
Yes.
Admittedly superannuated 31/3/20. This is the case of the authorities, even though they expressed the expressly promised writing that they will pay emoluments, they paid and again withhold in the SB account of post office in violation of their own express order. This is the second round of petition. In the first round ended partly allowing the petition, directing the respondent authorities instead of taking arbitrary decision, give opportunity to the petitioner and take decision. Accordingly, while they give in that they need to recall the withholding order of the SB account.
What is that order you are challenging?
My lord, before that, 3 points in the preliminary point, my lord. There is one insurance scheme in the Department of Post called Postal Life Insurance. There are 4 categories of the field sales force. Kindly visit page 71, Annexure B. Page 71, Annexure B.
Yes.
Kindly see, there are 4 categories of field sales force for soliciting and canvassing and procuring postal life in the business. One is department employee. Department employee means in-service employees.
No, that's typed copy ಹಾಕಿದಿರಲ್ಲ ನೀವು.
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಅದು ಪೇಜ್ ಯಾವ್ದ್ರಲ್ಲಿ ಬರುತ್ತೆ ಹೇಳಿ. 3.2 ನಾ?
3.2 or 3.3, whatever it means. 3.2.
3.3 renewal of incentives.
3.3 ತಗೋಬಹುದು ಸ್ವಾಮಿ. Page 75, internal page 3.
Yes.
Page 75.
Yes.
First category of departmental field sales force is called department employee. Left side first. He is one category of field sales force of the postal life insurance business.
No, that renewal incentive on PLI.
Postal life insurance. Postal life insurance.
Postal life insurance
Yes.
policy.
Yes.
This is department employees, one category of field sales force. They are trained, given IRDA license to procure the business outside the office hours, whether sultering sunny or raining weather, whatever it may have to procure business. They are promised they will give incentives procure business. They are promised they will give incentives, procurement incentive for 12 months. Thereafter renewal incentive whenever the policy continued by the policy insurer by paying monthly or annual quarterly, whatever it may be. So the field force department employee canvassing business under DE code, department employee code, they will promise will pay incentive until the policy subsists. Kindly see.
Petitioner apart from issue annexure seeking direction to the respondent.
One minute. Two. Page 73, typed copy. Procurement of incentive on postal life insurance. Premium of the first 12 months of PLA policy, procurement first year premium. The incentive payable on procurement of first year. This is
ನೀವು ಅಲ್ಲಿ ಎಂಪ್ಲಾಯೀಸ್ ಗೆ ಇದೊಂದು ಸ್ಕೀಮ್.
That's it.
Scheme employee skill assume. From the eligible public, they have to procure the insurance business.
ನೀವ್ಯಾರು?
He is a department employee retired as Group D on 31/3/20 retired. He was given DE code agency, asked him to go and procure the business. They will pay the procurement 12 months premium, thereafter annual premium. That is their promise in this executive order. Executive order.
I am asking him to
Yes, I'll
answer his question.
Make it
Yes,
in
yes,
2
yes,
minutes, my lord. What is the issue involved, so that my learned friend submits anything? I am not coming in a way.
Please have
No, no,
time.
no, no. I am
He's
asking
my
you.
employee.
That's all,
He's my
that's all.
employee.
That's all. Please.
I am asking to.
He is employee undoubtedly, undisputed.
No, I want that some reply from him.
Yes.
I have understood what you said. Let him say first. Yes.
That's it. He is our employee. He was there. There is a scheme where the serving employees can procure the postal life insurance. They have been given some incentive manners. Earlier, there was a notification which said was during
That he is
their
doing arguing on the merit facts of the case.
Yes, I am asking him to give that.
No, I am not my prelim. Otherwise, there will be misdirection.
No.
Misdirection.
No. You have what you said. This I understood. I want to understood from him his side.
And he is going full length,
Full
full
length.
dress rehearsal argument.
I want that. Yes.
No, I have not completed my argument.
I will come to you.
Yes,
Wait.
great.
Yes.
God bless.
till their retirement, whatever the premium collected, that was the rule. Till this retirement, that amount, incentive amount was paid on the premium collected, renewal as well as a fresher. So in this case, what happened? There were 12 people across India whose retirement date was not uploaded in the website. Because of that, for up to after retirement, some months they gave the incentive. His total incentive was 7,58,483 for the period 1/4/2017 to 30th June 2021. But while calculating the amount, what they calculated is period 1/4/2017 31 June 2021. 30th June 2021. Though he retired on the 30th June 21, one more year extra premium whatever was collected and the renewal premium also collected.
He has retired.
30th
31/3/20.
30th
No,
June.
1 month after retirement,
Then they said that this is, you are not entitled. That's how
you want to recover that.
recover that amount only. That's one aspect. Second aspect, subsequently, there is an OM issued. They say that even after the retirement, they are entitled. Only the cut-off date has been given in the memo. I will place affidavit to that extent. During the period 2020 and one more notice which was issued, my land friend has placed on record. Nobody is paid that amount. Subsequently, they are continuing. Place it on record because
Even after retirement, they are not entitled.
after in between for some
Entitled as
period,
per their promise.
for some period it was not there. Again, there was one more OM came.
Yes.
Then they have started only a date of the OM is there. After that only, not prior to that.
That's what your case.
That's not
Why
my
can't
case.
you extend him that he is
No.
also.
For them also, they can
Biased.
Waste.
all over India. For nobody, it is this for that period has not been extended. That's why I'll place it on record. It clear cut. Then lordship will pass orders. Just can it may have
No,
on Monday. That's the only thing.
Suppression of facts.
No.
Suppression of
Now
facts.
you show me that in the year 2020 you are retired.
31/3/20.
After that, 31/8/2021, which is that circular or a scheme is applicable to you that you are entitled for that
Yes,
incentive.
yes, my lord.
That period.
Yes, my lord.
That period. If you show that, then you are.
Yes, my lord. Kindly see. Ink page 9, annexure A.
Yes.
Second para. In this connection, details regarding the credit of alleged excess, it is not excess actually. Alleged excess incentives of 3,12,295 has been obtained from circle office, as incentive was being paid centrally at circle office during 2020, 21, 2023. Okay. Copy of the calculation sheet mentioning the incentives paid policy wise, wherein incentives due is marked green color.
ಪಬ್ಲಿಕ್ ಇಂದ ಪ್ರಕ್ಯೂರ್ ಮಾಡಿರೋದನ್ನ
ಇಲ್ಲ ಇಲ್ಲ ರಿಟೈರ್ ಆದ್ಮೇಲೆ ಅವ್ರು ಪ್ರೊಕ್ಯೂರ್ ಮಾಡಕ್ಕೆ ಬೇರೆ ಪ್ರೊಸೆಸ್ ಇದೆ.
We are not asking that.
ಅಲ್ಲಲ್ಲ
We are not
ಆಯ್ತು.
asking
ಈಗ ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ದನೋ ಅಥವಾ ನಿಮಗೆ ಗೊತ್ತಿಲ್ಲ ನೀವು ಕೊಟ್ರೆ ಅವರು ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ರು. But he has done some work for you.
No. That's according to that minutes. After
That is
retirement.
shocking facts, my lord. If I am given
I'm
opportunity.
not on that. What is that whether rule is there or not?
Yes.
But anyhow, you have secured that.
No. After retirement, he has not secured any policy. the incentive is paid, not
Retirement
after
ಆದ್ಮೇಲೆ
retirement.
ಕೊಡಲ್ಲ.
Now, no,
Al
after
yen
retirement,
agide-
there is a
al yen
separate
agide-
procedure.
Eh.
He can enroll again as field officer. There is a separate procedure. That's it only.
My lord,
Yes, now
during
yes.
in service under DE code, he has procured the business, he is entitled for the incentives, procurement incentive for the past 12 months premium. Thereafter, premium paid by the insured person, renewal 10 years, 15 years, whatever it may be. Until renewal.
Show me, even after you retired from the service, you are entitled for that incentives and which
Yes,
is the
yes, I'm saying. Two aspects are there. Express or implied contract, that is contract law, service law, equality before law. I'm having three approaches to my case. Kindly, I'll deal with the express and implied law. Kindly see, there. Kindly see page 69. 69. Here, red color, green color, details of the policies procured, renewal incentives paid. Kindly see from bottom 14th line until 1/3/20, 14th line from bottom. 14th line from bottom. During his service, retired superannuated 31/3/20. Before that, 1/3/20. And they say termination of agency and superannuation are discharged from service, whatever it may be. Discharged from service, superannuated, agency terminated. Here in this case, superannuated. Of superannuation, though he has done business and DG is not entitled, we are not claiming that as per their own list. Unless he takes field officer code, he is not entitled for incentive after superannuation. But we are claiming until superannuation, whatever he has procured business, procurement incentive, renewal incentive, as per the promise, he is entitled. Here they say, where is misinterpretation means, page 78, class 7.1. No procurement, renewal incentive will be payable in sales force of PLI, RPA, Rural Postal Life Insurance, not KPLI, RPLI, of termination of cancel office agent. This is where misinterpretation.
See, you have to show by retirement or superannuation that PLI and KPLI will terminate.
Yes,
Is there any circulation?
Yes, page number
I'll
70.
clarify.
70.
I'll clarify. Kindly, sir, kindly.
No, they have to show that.
No, what I say is,
Annexure
no
B.
procurement of under DE code for fresh policies procured. This fresh policies
Procurement or
procured after
renewal
superannuation,
incentives will be-
he is not
7.2.
entitled. But what about the policy procured during service and DE code?
No, whatever that you have procured, for that you will get incentive only if they are renewed.
Yes, that's all, renewal.
That they said renewal incentives will be payable in so and so is also cancelled. You are on procurement
And during service,
DE
code.
Even during the service, whenever they will renew, you will get an incentive.
Yes, even after superannuation.
No, that is not there. Where is that?
Direct agent from public, Gramin tax, Dak Sevak, that is different category. All
Now I understood what you are saying, that is not for that employee. If other agents are there, no, for them, whenever that persons who insured will renew, they will get an incentive.
That
For
is
you,
they're different.
only during that service.
Service. That is the
difference
condition.
that is misinterpreted here only. That is clarified further by departmental OM. Kindly see, after filing of this petition, they come back to census. Kindly see, memo dated 24/3/20.
Schema ಏನದು? What is that?
And normally to incentivize the people to procure the policy.
ಕೊಡೋದಕ್ಕೆ ಏನದು ನಿಮ್ದೊಂದು
scheme.
ಅರ್ಥನಿ.
Place it on.
When you
How
look
this,
at
on Monday.
whether after retirement is-
one second.
That is one.
ನಿಮ್ case.
One second, kindly.
Nagaraj,
It will-
your case
it will shake the conscience of this court.
Here, your case is very simple. After that retirement also, you are entitled for the
Renewal
incentives
commission.
or not.
See, here they are clarified. Clarified here, one
Where?
para.
So there is one
After
more
filing
issue.
of the petition, they come back to census. Kindly see, I filed the latest OM, I filed the memo 24/3/24, page 3. Latest memo. During the pending of these proceedings. Kindly see page 3, class.
ಇಲ್ಲಿದೆ memo.
memo along with filed office memorandum. They clarified that we retired employees, retired, don't come to me, they cannot say. That is not insurance trend. Here they said, DE, GDS, department employee, GDS will continue to earn renewable incentive even of superannuation discharge from service till the renewal premium and the policies procured while in service. Policies procured in service, service renewal till the renewal premium is received, provided he himself enroll. There is also illegal again.
ನೀವು ಈ ರೂಲ್ ಅನ್ನು ಮಾಡಿ ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಅಂದಿದಾರಲ್ಲ, ಇದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ? Have you challenged this?
This means and includes.
No.
Even if you don't challenge.
Yes, you challenge. I cannot say that whether it is wrong. Now that rule specifically says it is prospective.
And prospective from 31/3/25. ಇಲ್ಲಿ 31/3/25.
ಪ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಅಲ್ಲ, ವಿತ್ ರಿಟ್ರಾಸ್ಪೆಕ್ಟಿವ್ ಎಫೆಕ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ನೀವು ರೂಲ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಐ ಕ್ಯಾನ್ ಡಿಸೈಡ್. ಅದರ್ವೈಸ್ ರೂಲ್ ಸೇಸ್ ದಟ್ 2025. Then you are not.
No, one minute. Here interpretation, misinterpretation, very another one. Even worst in worst situation, service law, taken off decisions, whatever the emoluments paid, rightly, wrongly, once prepaid, they cannot recover it. In this case, I'm ruling right now in my hand.
That you see that not to recover that excess pay.
Rafiq Masi and that matter. No, actually that
Rafiq Masi was distinguished. There is one more judgment we got today, my lord.
No, that is, can it be applied this for this case?
No, this does not form part of even service conditions. Those things are under the service conditions.
Whatever it may be, emoluments
that
paid,
is, they have specifically said group C, group employees in the. I don't think you can apply that also.
Yes, because it's not service related.
It is clear.
I will decide that you.
And our own High Court division bench matter is there.
This is unlawful, illegal. No, that is page 78, and no procurement annual incentive will be paid to sales force. Procurement of sales, retired procurement, boroda lakadra, DE code seizures on superannuation. Renewal incentive will be paid sales force of termination. He has to service the policyholders. They were paying all along. In this case, they paid. Yes, they paid into SB account, post office SB account. Art was marketed a lien. That is illegal two ways. Renewal of retirement, he has not procured any business. But renewal premium is paid.
If you don't want to challenge that circular, then you will hear that matter on merit. Will decide.
No, I will amend my question.
You do it. Let us see that after filing that. Yes, Karnataka Council for the petitioner. Waste 2 weeks time. Leave this matter after 2 weeks. Let him file an application. Then we'll see. Yes.
Ramesh, MOV for petitioner, connected matter.
I'm appearing for the petitioner in this case, my lord. The state has been asked to file some affidavit with regards to the annexure C, the applicability date of
May I
the.
request, my lord. Lord, a week's time, request, my lord. Lord, a week's time may be granted, my lord. We will file affidavit in this.
What is this?
Yes, it's a case wherein the petitioner has applied for a post.
What is the relief you sought?
Relief is sought is to consider her case for interview. Because as on the date of application, she was not eligible, but before the date of interview, there came to be annexure C, which extended the date.
What is this?
Eligibility date by 2 years.
Yes.
My lord, regarding annexure C, information has been sought, my lord. We are awaiting instructions from the office.
What is that C, annexure?
Annexure C is relaxation in age in the matter of recruitment to the post of assistant lecturers in aided institutions, my lord. Because of COVID, there was a 2-year relaxation.
Yes.
For the one year period. Annexure C, which is at page.
What is that information you have to get?
We have sought instructions. We have not yet received any.
Wait.
ಪೇಜ್ 19. ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜುಗಳ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ಹುದ್ದೆಗಳ ನೇಮಕಾತಿಗೆ ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ ದಿನಾಂಕ 26/18 ಮತ್ತು ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ ಸೋನ್ಸೋ 13/12/2018 ರಂತೆ ನಿಗದಿಪಡಿಸಿರುವ ಗರಿಷ್ಠ ವಯೋಮಿತಿಯೊಂದಿಗೆ ಖಾಸಗಿ ಅನುದಾನಿತ ಪ್ರಥಮ ದರ್ಜೆ ಕಾಲೇಜುಗಳ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರ ನೇಮಕಾತಿಯನ್ನು ಕೋವಿಡ್-19 ಸಾಂಕ್ರಾಮಿಕ ರೋಗದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 2 ವರ್ಷಗಳವರೆಗೆ ತಡೆ ಹಿಡಿದಿದ್ದರಿಂದ ಒಂದು ಬಾರಿ ಮಾತ್ರ ದಿನಾಂಕ 23/6/22 1 ವರ್ಷದ ಅವಧಿಗೆ ಮಾತ್ರ. So for this period 2 years relaxation is given. ಗರಿಷ್ಠ ವಯೋಮಿತಿಯಲ್ಲಿ 2 ವರ್ಷಗಳ ಸಡಿಲಿಕೆಯನ್ನು ಮಾನದಂಡವು ಮೊದಲ ನೇರ ನೇಮಕಾತಿಗೆ ಮಾತ್ರ ಅನ್ವಯವಾಗುವಂತೆ ಗರಿಷ್ಠ ವಯೋಮಿತಿಯನ್ನು 2 ವರ್ಷಗಳಿಗೆ ಮಾತ್ರ ಹೆಚ್ಚಿಸಿ ಆದೇಶಿಸಲಾಗಿದೆ.
What is the case of the petitioner?
May I submit, my
She
lord?
has not been, the case of the petitioner is that somebody who is less qualified has been
May I
and she has
submit, my
been
lord?
considered as being age barred.
Yes.
May I submit, my lord?
Yes, Mr. Yes.
Yes. Petitioner has applied for the post. The application was called during the month, has applied for the post. The application was called during the month of March 2023.
Yes.
And he applied. As on the date of application, she was overaged by 2 months or so.
Yes.
But there was
Yes.
no interview or nothing as held. As in
Yes.
in the month of May, the relaxation was given.
Yes.
The relaxation period
Yes.
comes to the aid of this petitioner also. As there was no interview held as on that day, she makes an approach. But by the time she gets an intimation that the interviews are held, she approaches the authorities and also the college. The last annexure is annexure F. It is from the response from the college at page number 28, my lord.
Yes.
ಸೊ ಅದರಲ್ಲಿ ಮೇ ರೀಡ್ 2 ಪ್ಯಾರಾ ಓದ್ತೇನೆ ಅಷ್ಟೇ. ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತುಂಬಾ
Read relevant paragraph. Yes.
Yes.
ಪತ್ರಿಕೆ ಜಾಹೀರಾತು ನಿಯಮಾವಳಿ ಪ್ರಕಟಣೆ ನೀಡಿದ
33/2023 ದಿನಪತ್ರಿಕೆಯಲ್ಲಿ ಜಾಹೀರಾತು ನೀಡಿರುತ್ತೇವೆ. ಪತ್ರಿಕಾ ಪ್ರಕಟಣೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ಸಾಮಾನ್ಯ ಅಭ್ಯರ್ಥಿಗೆ 40 ವರ್ಷಗಳ ವಯೋಮಿತಿ ಇರುತ್ತದೆ. ನೀವು ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ಸಂದರ್ಭದಲ್ಲಿ ನೀವು ದಾಖಲೆಯ ಮೇರೆಗೆ ನಿಮ್ಮ ವಯಸ್ಸು 40 ವರ್ಷ 2 ತಿಂಗಳು 1 ದಿನಗಳಾಗಿದ್ದು ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಸರ್ಕಾರಿ ಆದೇಶದ ಪ್ರಕಾರ ಅರ್ಹತೆ ಇರುವುದಿಲ್ಲ. ಈ ವಿಷಯದ ಬಗ್ಗೆ ನಿಮಗೂ ಅರಿವಿರುತ್ತದೆ. ನೀವು ಅರ್ಜಿ ಸಲ್ಲಿಸುವ ಸಂದರ್ಭದಲ್ಲಿ ನೀವು ಈಗ
filed an application, he was overaged. Subsequently, that relaxation has been, he was overaged. Subsequently, that relaxation has been given. Now, what is that instruction you have to get, Mr. Application?
We rejected her, we did not consider her for the candidature, then elections came up. So the selection, actually interview got delayed. So admittedly, as on the date of we giving notification and she making application, she was not eligible.
ಯಾವತ್ತು ಹಾಕಿದ್ದು?
Hey, Lordship may kindly see annexure A is the application.
Date.
So I stand corrected.
notification. B is the application.
Her application annexure B page 13, advertisement is dated 3/3/23. Her application, my lords, date
16/3.
is 16/3/23.
16/3?
16/3/23 is the annexure B, my lords.
Now the question is only, this notification is applicable only after 18/5/2023 or before that?
Before that.
Yes,
is the
yes,
question.
that is
That have to be answered. That is what. See,
Yes.
this
The
benefit is
notification
given
makes it clear.
only after the government has issued.
Here two issues, my lord. One is, assuming for the sake of argument that she is entitled to, she has approached the government, made a representation after every process of appointment was completed.
No.
Until such time she slept over it.
No, that
And the other person has already been appointed.
that limitation will come later. First, let us see whether it is applicable to that all pending or recruitment which is pending.
Because
May I make
from
a
the order
submission,
itself, it seems like it is from the order
May I
itself,
make
it
a
looks like it is
submission,
retrospective.
ಇವುಗಳ
Because
ಹಿನ್ನೆಲೆ
for the
2
period
ವರ್ಷದವರೆಗೆ
between 23
ತಡೆ ಹಿಡಿದಿದ್ದರಿಂದ ಒಂದು
22ರಿಂದ 1 ವರ್ಷದ ಅವಧಿಗೆ those notifications which are made from 23/6/2022 to 1 year, and the relaxation is of age relaxation
2 ವರ್ಷದವರೆಗೆ ತಡೆ ಹಿಡಿದಿದ್ದರಿಂದ notification which has been issued and which has not been because of that COVID. For them, there's benefit has been given.
My reading is that the notification is issued within that 1 year period.
No, it is not 1 year, my
The
lord.
only issue is now that selection was completed. This, as on the date of issuance of this notification, selection was already completed.
No, it is not.
Not
ಈಗ
completed.
ಮೇಲ್ಗಡೆ
Not
ಇವರದ್ದು
completed, but
DPR
she was
opinion
her
ಇದೆ
candidature was
ಮೇಲ್ಗಡೆ.
rejected by that.
That is what that no question.
In any case, my lord,
What
the
stage it
notification
will
is
be
within
applicable?
notification is within that 1 year period.
No, what stage it will applicable? See,
ಅದನ್ನು
whether
may make a submission, man. I want to
interview
clear
is
it. Fine.
completed.
Because the age is calculated as on the last date for submitting applications, my lord. It would follow that the date of the last date for filing the application would be the relevant date. It should fall the last date for the relevant date. It should fall the last date for filing the
That means to
application.
say that all applications which has been filed before 2023, they're not entitled. Then it should be from 23 itself. ಅದಕ್ಕಿಂತ
Between-
ಮುಂಚೆ
They have to issue re-notification.
ಏನ್ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ಲಾಸ್ಟ್ ಡೇಟ್ ಆಗೋಗಿರುತ್ತೆ. 40 years ಒಳಗಿದ್ದಾರೆ ಹಾಕಲ್ಲ. Then that means to say that it is only 23. That cannot be.
No, it would open Pandora's box, my lord.
ಇದು
because-
22ರಿಂದನೇ ಅಪ್ಲೈ ಆಗೋದು. ಬಟ್ 22ರಲ್ಲಿ ಯಾವ ಸ್ಟೇಜ್ ಇಂದ ಅಂತ ಪ್ರೋಸೆಸ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದಾವ ಅಥವಾ ಅಪ್ಲಿಕೇಶನ್ ಇಫ್ ಯು ರೀಡ್ ದಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. Process is not completed because of COVID. It has been extended. Therefore, they said that you apply that. Otherwise, ನೀವು 2 ವರ್ಷ process ಮಾಡದೇ ಇರೋದ್ರಿಂದ.
2 years.
No, now if you read this notification which is issued after 2023, if he has crossed 40, they are entitled. What is that? Because of COVID, it has been extended to 23. 23 notification, if it is crossed 42, you take that anta. That is what the meaning. If that notification issued in the year 2022, I don't think it is applicable.
Notification is annexure A, my lord.
What is the date? It
So
is in
online ಇಂದ ಡೌನ್ಲೋಡ್ ಮಾಡಿದಿರಿ ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ಅದರಲ್ಲಿ
No,
ಡೇಟ್
it is
ಕಂಡು
not
ಬರ್ತಿಲ್ಲ.
disputed by the management. ಅವರು ಅದನ್ನ
Now,
ಹೇಳ್ತಾರೆ.
Mr. Joyce.
The notification is dated, my lord, 3/3.
3/3.
Advertisement
3/3,
date,
23.
your lordship will get at annexure B. ಅವ್ರ ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲೇ ಬರೀತಾರೆ ಡೇಟ್ ಆಫ್ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್, my lord, ಕೆಳಗಡೆ ಬಾಕ್ಸ್ ನಲ್ಲಿ
ಎಷ್ಟರಲ್ಲಿ
ಅದೇ ಅದರಲ್ಲಿ lordship ಆಫ್ಟರ್ ಹರ್ ಫೋಟೋಗ್ರಾಫ್ ಡೌನ್ ಅಲ್ಲಿ ಥರ್ಡ್ ಒನ್ ಅಡ್ವರ್ಟೈಸ್ಮೆಂಟ್ ಡೇಟ್ ಇಸ್ 3/3/23.
ಸಿ ಇದರಲ್ಲಿ ಅರ್ಥ ಏನ್ ನೋಡಿ, ಇಲ್ಲಿ ಸಹಾಯಕ ಪ್ರಾಧ್ಯಾಪಕರು ಕೋವಿಡ್ ಸಾಂಕ್ರಾಮಿಕ ರೋಗದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ 2 ವರ್ಷಗಳು ತಡೆ ಹಿಡಿದಿದ್ದರಿಂದ, ಅಂದ್ರೆ 2 ವರ್ಷ ನೋಟಿಫಿಕೇಶನ್ ಮಾಡದೇ ಇರೋದ್ರಿಂದ ಇದು 3ನೇ ವರ್ಷಕ್ಕೆ ಹೋಗುತ್ತೆ. ಅವನಿಗೆ ಅವಾಗ 2 ವರ್ಷ ಜಾಸ್ತಿ ಆಗಿರುತ್ತೆ. ಅವ್ರಿಗೆ ಮಾತ್ರ ರಿಲ್ಯಾಕ್ಸೇಷನ್. ಅಲ್ಲಿ ನೋಟಿಫಿಕೇಶನ್ ವಿಚ್ ಇಸ್ ಇಶ್ಯೂಡ್ ಆಫ್ಟರ್ 18/5/2023, ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅಪ್ಲೈಡ್. ಸಿ ಈಗ 18/5/2023, wait mister, 18/5/2023, if the notification issue, wait mister, 18